This is key to regulators. If you have a data breach, particularly, then regulators are going to ask you about your training, ask you about awareness. And it also enables you, if you want to say that it was a rogue employee who did something bad, the only way you're going to be able to persuade a regulator that it was a rogue employer is if you can point to policies, procedures, contracts with that employee, or whatever that might be, and the training piece as well. So training's the sort of the critical thing. It's the mustard that runs through your hot dog, the dill pickle on your burger. It's sort of inherently has to be there in everyone's data protection program. Now, if we look at the next slide, if we can, Matt, the other, I guess, a climactic thing we have to consider is that, and I know most of you are with US corporations, and unfortunately, I think US corporations particularly start with a little bit of a disadvantage when it comes to areas like GDPR. There's the technical disadvantages like data protection representatives. We'll talk about that briefly in a minute. But the thing that US corporations always have to counter is the fact that many in Europe will say that people in the US just don't get privacy. I think in some respects that's an outmoded concept. I think that many in the US do get privacy now, but you're going to have to go, if you're a US corporation, you're going to have to go that extra mile to persuade a regulator that you understand this. And the key thing to start off with is that you don't just train European employees on European data protection issues. If you have HR professionals in the US that can get into the PeopleSoft database and look at data on EU nationals, then they need training on EU data protection law as well. And in many respects, they need more training because they've got to get across that cultural hurdle where the regulators will think, well, personal data is a core European value. Does that HR manager in the US get that? Because of these different political reactions, because of this different approach between Europe and the US, what one regulator has called a war between two cultures. And it's also the case that, unfortunately, the Snowden allegations, the allegations that the US used computers to spy on everyone in Europe, they've certainly made it more difficult for multinational corporations. The Schrems litigation, for those of you who have followed that, Schrems is the Austrian law student who had safe harbor struck down. By the way, on Tuesday, we're expecting judgment in his latest case over there with some of you guys from Interactive in Dublin, which might hit standard contractual clauses, the way most people are using to transfer data. So all of this litigation and these allegations have fueled this fire that multinationals are facing. It's important to remember as well that GDPR is already a reality in many respects. If you lose data now, some regulators are going to judge you by GDPR standards. They might not get to the same level of fines. Some, like Italy, will try and get close, but they are certainly going to want to judge you by GDPR standards, and that will include things like training, and obviously we'll talk about that in a minute. And it's important to remember that the EU also wants extraterritorial reach, and we'll mention that briefly in a minute as well. So what are the basics? If we look at the next slide, please. Well, first of all, what is personal data? Now, the first thing I think you need to do in your organization, if you're a multinational, is almost have a swear box, if you're familiar with a swear box. If anyone says personal data is the same as PII, you want to fine them and pay that money to the Houston or Florida relief funds or wherever your favored charity is. Personal data is not the same as PII. Anybody who says that, I think, is heading for disaster. PII generally has a very precise definition in US data breach legislation, for example, and it's a set list of things that are PII. Personal data is almost the opposite. Personal data is any data that's personal, broadly. So it isn't a set list of things. It can be IP addresses, it can be MAC addresses, it can be identifiable or identified. So if you've got one set of data on somebody and somebody else has got another set of data, you can combine those together, even though it's what's called pseudonymized, even though you haven't got a name against that, then it's still personal data. Sensitive personal data is going to be renamed under GDPR, but sensitive data is a higher class of data that needs extra protection. It's things like marital status, health, and it's very easy to collect stuff like sensitive personal data in areas like internal investigations, for example, or even stuff as simple as people booking hotel rooms, asking for a ground floor room because they have a disability, asking if they can be seated next to a toilet on a plane or whatever that might be. And the difficulty with most of our organizations is we do less and less ourselves year by year. We use outsourced providers to manage stuff. We use cloud applications. And that obviously means that the only line of defense often we have is our own employees, because we can't discipline, PeopleSoft or Concur or whatever, because we don't own those employees. We can't ask them to look out to take as much care of the data as in the olden days when everything was on a manuscript in our own offices. So data is regulated by data protection regulators. They're generally one per country in the EU. Germany would be the exception, where they're on a regional basis, and regulation currently is under domestic data protection law, which follows an EU directive, and post GDPR that's more or less the same. GDPR will apply across the EU, but countries can add their own law in as well, like Germany has done, like Austria plans to do, like Ireland plans to do, and we have a UK draft bill already on data protection law as well. So if we look at the next slide, the most common question I think we get at the moment is, does GDPR apply to US companies, US corporations? Well, I can summarize that slide in the interests of time by saying almost certainly yes. And remember that if you're a corporation that's not resident in the EU, even if, let's say, one of your subsidiaries is, then you'll probably have to appoint a data protection representative, and they stand in shoes for things like fines. Note that a data protection representative is very dissimilar to a data protection officer. Data protection officers have like a monitoring role. Data protection representatives stand in the shoes of the principal. And then very quickly, if we look at the next slide, I'm going to try and rattle through some of the key things of GDPR. And these are the key things that I would be wanting to train my employees now. Now obviously, we're going to have more detailed job role-based training for different parts of the organization. But I think anybody who touches EU personal data, I'd want them to know things in three areas. We've tried to split GDPR into aims, benefits, and consequences. So looking at aims, what is the law trying to do? Well, the key thing I'll single out to start off with is this thing called data protection impact assessments. It's a real training opportunity. It's a real opportunity to reduce risk. So if you're introducing a new way of handling data, let's say you're a bank, you're introducing a new mobile app, you have to go through a process not only to do the business case, does this make sense financially, but almost like a privacy business case as well. Does this make sense from a privacy point of view? And I think that's one of the key things to understand GDPR, and I think we need to get our employees comfortable with the DPIA process already and get them doing DPIAs. You'll have to do a DPIA within 3 years of GDPR starting anyway. You'll have to do it for any new process that starts after 25 May 2018. So get people good at that process. Okay. I'd also
sorry, I'm just going to jump in because the questions come in that I think we've actually had a few questions in, and some of them can wait, I think, till the end of the session. But one I would like to cover now because it may be important. The question is a data subject a citizen or a resident or both in the EU?
Yeah, I think that's a really good question. And remember that to be a data subject, you needn't necessarily be an EU citizen. So under the existing law, for example, we've some litigation that concerns two sets of Russian oligarchs fighting each other. So oligarch A thinks that oligarch B and his wife stole shares in their company. They have proceedings ongoing, Russian versus Russian, in Cyprus, but they engage some litigation support guys in London. The Russians could still make a subject access request, one of the new rights in one of the existing rights in data protection law, but one that gets supercharged and go faster stripes in GDPR. They can still make it without being EU citizens at all. So remember that while some of the extraterritoriality provisions rely on, monitoring behavior of EU data subjects and things like that, the touch point with the EU can be smaller. And the other thing I'd say on that, Matt, is organizations actually aren't very good at working out the nationality of people anyway. A lot of organizations will second people around the organization. And if you've got a Dutch guy sitting in Chicago, do you want to treat him differently from the guy who's born in Illinois who's sitting next to him? If they're doing the same job role, they're sitting at the same desks. So I think for many corporations, there are all sorts of challenges if you're trying to run a different policy for EU nationals versus those who aren't EU nationals, even if that helps you comply with the law. I'd say maybe one other thing on this, which is that the direction of travel is in favor of GDPR-like rules. So if you look at countries like Japan, South Korea, they're engaging with the European Commission. Why? Because everybody wants what's called an adequacy decision, and they know that the way to get listed as a safe nation by the EU is to adopt legislation that looks almost identical to GDPR. I think that answers the question, Matt.
I think it does. Yeah, and sub. Thank you.
Okay. So a couple of other things on this slide. Obviously, as I've said, toughened enforcement bodies, still local, powers to audit and dawn raid. They will be looking for training records, I'm pretty sure. Breach reporting in 72 hours. So if you have a breach, you have to tell the regulator quickly. Again, huge ramifications for multinational corporations, because that might mean you have to tell your home regulator quicker as well. Obviously, under existing data breach statutes in places like the US, you might have to tell a regulator, your AG, in 28 days. That time gets compressed. Distinction between data processor and data controller diminishes. I won't do that in any detail. You might have to appoint a data protection officer. And this whole issue around data transfer, we touched briefly on Schrems, becomes an issue again. So you need to be training your employees not to send data from the EU outside the EU to places like the US, to India, without checking with a grown-up first, without checking with somebody who knows what these rules are and how you're going to work through them. If we look at benefits, I think I can touch on this very shortly. We have to be educating our employees to recognize all these new bits of GDPR, the fact that consent is less of an option. So if they're having a trade fair, they're going to have to look very carefully at how they're legitimizing the obtaining of data. We have to educate people in these new rights, like the right to be forgotten, right to data portability, right to objective profiling, the enhanced subject access regime I've touched on briefly when talking about the Russia case. This is going to be huge. We know that subject access requests are going to be used a bit like DDoS attacks. So if I'm a company and I'm a fashion company and I've had fur on the catwalk, people get mad about it. They start Facebook petitions. From 26 May 2018, they'll be launching subject access requests instead. And we know that they take 150 to 300 man-hours to deal with. And if you deliver even 100 at once, most corporations would have struggles. So the training there, I think, is telling people how to recognize all this stuff, how to get it quickly to somebody who's going to put a process in place to handle this and respond. And we're very much about, sorry, Matt, I was just going to say quickly, we're very much about training people, recognize, deal with, do it immediately. And your policies and procedures also have to be tight, small, couple of pages to match that as well.
Yeah, and I was just going to jump in with a question, Jonathan, which is how much of what you're talking about right now is relevant to people who actually work with data frontline, and how much of it would you consider to be general awareness that everyone in an organization should have?
I think most people who could touch data should be trained, I think. And I think I'd distinguish by job role. You know that there are people in HR or benefits or pensions, or I don't know, if you're a hotel chain, the people who manage dietary needs or whatever that might be. You'll know that there are people who need special training. But you do need to include people who touch EU data wherever they're located. And you also need to include people like developers, procurement people. I was interested that that's a module you're having, because of course that's your way of reducing risk. If you're going to procure a new travel management system, then you need to build GDPR risk into that whole procurement process. You need to be saying to the people you invite to tender, tell me about your GDPR compliance, tell me what you're doing about GDPR. And if they say to you, PII is the same as personal data, isn't it? Strike them off the list. If they say to you, we're not going to give you any warranties that we comply with anything, strike them off the list. So your procurement people need to be involved in this process, even if they don't touch any personal data themselves.
Okay, thank you.
And then if we go to the next slide, really briefly on consequences, obviously more to do for data controllers and data processors. So I know that some of you on the list actually handle data on behalf of other people. Under the current legislation, there's not that much for you to do. The principal obligation is on the organization that's asked you to do that thing with the data. But obviously under GDPR, you will have liabilities as well. Remember that there's an enhanced ability to bring class actions. Again, we're seeing that trend already in Europe. That's one import that we have to thank the US for. There are fines of up to 4% of global annual turnover, or 20 million euros. So if you're a small organization, 20 million euros is the maximum. If you're a large organization, 4% of your global annual turnover. Turnover is effectively the same as revenue. We'll have shared investigations across the EU, much greater reputational risk. We're seeing a lot of shareholder and investor engagement, particularly private equity organizations, for example, worried about their value of their asset diminishing. And increasingly, I think, in the last 2 or 3 weeks, we're seeing much more customer interaction as well. So just before this, I was with a the software and services vendor, a big corporation, and we're going through their GDPR plan with them. And they've had a massive questionnaires this week. It's almost as if people have come back from vacation and they've thought, the next thing to do is send a GDPR questionnaire to all my vendors. So either you manage this process or it manages you. And obviously, if you can say to people, yes, we're already on with our training program, here it is, this is what we're doing, then that'll at least allow you to get rid of some of those inane questions that we're all going to face over the next 239 days.
Jonathan, what you just said ties in, I think, with a question that we've had through the WebEx platform, which is around third parties and vendors. So the question is, how do you see corporations being able to shop for vendors and see certification of GDPR compliance? In short, how will organizations know that their own vendors are compliant and trustworthy?
Yeah, I think that's a great question. So the first thing to say is those people who claim to be a GDPR certified vendor, and I've seen some, well, that certificate isn't worth the paper it's not written on. There is a procedure by which you can have a certification scheme under GDPR, as an oversimplification, that will be handled by national regulators rather than the European Commission. But those schemes are in their infancy. I think there are a couple of schemes that exist with some of the German regulators, but obviously they're certifying to the existing law, not to GDPR. In the UK, for example, the bill enables a national certification authority that will be specified by the UK government or the Information Commissioner's Office, the data protection regulator, to authorize certification, but that's still at least a year away, I would have said. So if somebody produces a certificate to them, to you, that would be a sign that they don't know what they're doing. I don't think anybody is GDPR compliant as a vendor at the moment. I don't think many people will be fully GDPR compliant by the deadline, but I think you can sense check whether people know what they're talking about. You know, we've developed screening questionnaires, for example, for clients where they can send it to vendors at the first engagement stage, and if they answer, you know, what is GDPR, can you explain what the initials are to me, they're probably not the right vendor for you. But equally, if they say, yeah, we think we're 50% of the way to where we should be, and we've done these 5 things already. We do DPIAs, we've got a subject access request policy, we've got a data breach policy, we've done training around them, then equally that would be roughly the position I'd expect most vendors to be at the moment.
Okay, thank you. I'm going to just put in a sort of 5-minute warning on this, Jonathan, I think, and then we'll...
Yeah, so if you go to the next slide, let me rattle through these. So what would I be doing in terms of GDPR? Well, obviously, you've got to have an overall compliance plan. Training's an element of that. We'll talk about that. DPIAs I've talked about already. Have a proper data breach response plan. Train people on that. You won't need a lot of training if the plan's intuitive. Invest in proper technologies and processes. As I've said, processes are part of it, not just technology. Vendor contracts we've just discussed briefly. Be aware of the fact that this is all subject to audit or review. If you look at the next slide, we've talked briefly about consent already. We've talked briefly about these new rights. Obviously brief the board, not only because they ought to know, but also because they need to allocate budget for this. I've heard this week of one household name global multinational that's been given $50,000 to sort GDPR. That's just not going to work. And if you're in an organization that's allocating that smaller budget, you are not going to be able to comply with GDPR, and you may need, or the board need, to consider their annual report. If you know, it's 4% of global revenue is the penalty, plus class actions. That might be something that if they've taken the decision that they're not going to comply, then they have to disclose that in their accounts because of their duty to shareholders. Obviously, you have to train staff on all aspects of the law. I wouldn't train them on the law per se. I'd train them on the principles behind the law. People switch off, and we've had these discussions, Matt, over the years. If you show them sections of a statute and make them read it, but people do get the fact that you have to look after customers' data, you have to look after co-workers' data, you have to do unto others as you would be done to yourself. You're obviously going to need to check that regularly. In the area of training, you're going to have to audit training. You're going to have to do things like make people answer tests, even if it's face-to-face training, and have those records ready for inspection. As I say, they're your first line of defense, I think, if a regulator comes knocking. And finally, sense check your plans with specialist lawyers. I'd say finally, and not the least important, for 2 reasons. Firstly, I think it will stop you getting into some serious issues. Maybe a second reason would be, I think it's good to have somebody who already knows what you've done when you do have an incident, given that there's only 72 hours. You know, we've had to report breaches under the existing law for clients, but when we've already done some of the policies and procedures, we can speak to them much more authoritatively to the regulator and walk them through the preventative measures. And the third reason I'd say is, as you know, Matt, I've still got 2 kids to get through college. So hire good lawyers. Don't regard it as a plea from a lawyer for money. Regard it as an opportunity to sort of crowdfund my daughter's education. So with that, I'm going to ask that you click onto the next slide, which gives you some resources. Obviously, it's impossible to go through what's a huge piece of legislation in 20 minutes. So there's some links to some other things if you're interested in that. And then I think, Matt, we've still got time for some questions if there are any more.
Yeah, I mean, actually, it was. Thank you so much, Jonathan, first of all. And I think we've actually covered out some of the more important questions. A few people are asking if they can have a copy of the slides today. In fact, one person was very keen to point out they'd like it as soon as possible. And the answer today is absolutely yes. I'll talk about that in just a moment, but we will be sending those out. In terms of, I mean, that was very thorough and comprehensive, Jonathan. I've got a couple of questions I might ask, actually. And just to anyone who's on the webinar, there's still an opportunity if you want to put a question in to Jonathan. You still have time. But so if I'm on this webinar and I haven't yet done anything about GDPR, and I'm sure there's no one on the webinar who's in that situation, but if there was, what's the first thing they should do? What is the first thing they should do to get moving on this?
I think what we've done with clients is we've sat down with them and we've said, okay, what are the big things that you're going to get a high fine for? I'm not a fan of these data mapping exercises that try and measure the inside leg of everything, because I think you just get a huge list of problems and then you've run out of energy to fix them. So for most organizations, there are some really quick wins. As I've said, the 2 most serious data breaches we've had this year have been manual data. A £1 padlock from a well-known superstore on that briefcase would have meant that we probably didn't have to report the breach at all. So there are some quick wins there. Do the quick wins now. Firstly, because that's a good way of doing something. Secondly, because risks are out there now. And thirdly, because it can show a regulator that you're serious and that you mean business. So for most organizations, they can get a list of about 10 things that they haven't got that they can be fixing now. And that's going to be things like a data breach plan, keep it simple, a little bit like a fire exit on the back of a hotel door. It tells people what to do in an emergency. A subject access request policy, pretty easy thing to do. A good lawyer will do that in a couple of hours. Another quick win. Look at your privacy policy. It's probably pretty out of date. Most people's are. Get that tuned up. Not only because that's a good thing to do, but again, it'll show a regulator. That's one of the first things they'll look at. And obviously, you've got to start an awareness campaign as well. That might be slightly different. We can argue whether awareness and training are the same, but you've got to tell people that you're on the case. You've probably got to tell people that you're on the case even if you're not, because otherwise they're going to go and set up their own projects, talk to people, go rogue, make things up. There's a well-known case of a leisure chain in the UK where an operative, one of the individuals got really worried about GDPR and destroyed their entire marketing database because they thought it was easier than talking to good lawyers about whether they should keep it. So that's gone for good now. They
That doesn't sound like the best approach. Jonathan, I have 4 rapid fire questions for you. Are you ready?
Yes.
This will come from the crowd. Number 1, that makes my heart sink. Is the GDPR applicable to Britain, and will it continue to be applicable after Brexit?
Yes and yes. And there's an alert at www.bit.ly/UK GDPR, which will expand.
Thank you. Second question. Can you give a very quick overview of the GDPR trans-border scope? I'm hoping you know what that means.
I'm guessing they mean data transfers, so transfer of data from the EU to the US. Simple answer is nothing much changes. So the options are still, as we sit here, possibly privacy shield, possibly consent from the individuals, possibly standard contractual terms. But remember that there's this case on Tuesday that could kick those out. and binding corporate rules. Binding corporate rules become the favored child under GDPR, and I think that's the one big change. They go from a sort of a commission-invented thing to a statutory footing. BCRs might be the answer long-term for organisations.
Okay, thank you. Next question. Is Latin America far behind, and should they be complying now with GDPR standards?
Varies through the different countries in Latin America. Some of them are already talking to the Commission. There is also a sort of cooperation group in Latin and South America, the same as there is in APAC, and most countries aren't too far behind.
Okay, thank you. Next question. We are a US parent company and have subsidiaries in the EU. We have mostly employee data hosted by our third-party service providers, for example, ADP or Concur or Amex. What kind of protocols or agreement can we use between our US parent and EU subsidiaries? And let me know if you'd like me to read that out again.
No, that's fine. I mean, the first thing I think is to look at your relationship with the vendors. That's probably where your biggest risk lies. So look very hard at the contracts that you have in place with those vendors. It must be a written contract by law, under the existing law as well, must be in writing. And they must have skin in the game. So if they're capping their liability at a year's revenue, for example, that probably doesn't comply either under the existing law or under GDPR. So take a hard look at the contracts with those vendors. And then for the what's called the intra-group transfers, so the stuff that's going from the EU subsidiary to the US parent, consider one of those measures I've discussed. Privacy Shield, although that scheme is under challenge and might die. Standard contractual clauses are likely to be the simplest answer for most people in the short term. Binding corporate rules is probably the destination for many going forward.
Okay, thank you. And the last question I have, so we'll try and make it the last question of the day. The question is actually, would you see that we will be viewed as lower risk than other companies? I'm not sure which organization the question came from, but what I think reading between the lines, they're asking, are EU regulators differentiating between companies that work very much in data, for example, Visa, Facebook, and companies that perhaps data is obviously part of their organization but not central to their business model?
Yeah, I think the first tier of enforcement action will be those companies who have a lot of data. So yes, you're right, Google, Facebook, people like that. But of course, many of us interact with businesses like that. You know, if you look at Google, for example, even if I look at our website, you know, we're a small niche law firm, but we use Google Maps to show people where the office is. We use YouTube to host films. So a lot of us interact with those type of companies anyway on a daily basis, and I think a lot of this will be security breach led. So even if you're, you know, a relatively small company that isn't regarded as a data handling company, then if you have a breach, you will be under investigation. You know, look at Deloitte, for example, where I believe that the regulators said that she's now interested in their recent data breach. Nobody would have put them down as a data-driven organization, I think, but equally, if they lose data, then they will be investigated for that. So my suspicion is that most of the enforcement action is going to be data security related initially. And again, that's why training is absolutely important, because that's your first line of defense to a security breach.
Okay, but I think it's pretty clear that this is something that affects everybody.
Yeah.
Jonathan, thank you so much. That was fantastic, and I'm really glad we were able to answer so many of the questions. Thank you, everyone, for attending today. I think it's been a really valuable session. My colleague Jim will send you an email to everyone who's on the phone today. Please let him know if you'd like demo access to our GDPR module, or if you have any specific questions you think ourselves or Jonathan will be able to answer. And yeah, it just leaves me to say thank you once again for joining. And Jonathan, is there anything you'd like to say just to close this out?
I guess just one last thing we didn't cover, refresh the training as well. If you did training 3 years ago, it's too old, do it again.
Very good. All right. Thank you, everybody.